Um, I'll be posting these screenshots of, or you can just take screenshots na lang siguro of the screenshot of our class module, right? Because sabi ko nga, internal arrangement na lang natin because supposed to be this is not intended to be shared to students outside of our school. But for purposes na gusto ko ma-wrap up talaga, ma-fine-tune kung ano man yung iba pang salient points regarding arrest. So that's why I'll be sharing this to you. Right? So your examination, I think, will be this coming Tuesday. Tama ba? Or Thursday?
Tuesday, sir.
Tuesday. So you'll have enough time to prepare for your midterm examination. Alright, so aron makaano ta kay Sunday ron, tas na ay mga mga obligasyones gihapon, pamilya. So, yun. Sure. Wait sa. Kana. Alright. No problems. So, already, we have established some of the salient points regarding arrest. But, let me just put emphasis. No? So, etymologically speaking, the term arrest came from Latin word arrestare, which means cause to stop, and restare, which means to stay behind. So, this term was used as early as 14th century, and technically speaking, an arrest is the taking of a person into custody, the purpose of which is to answer for the commission of an offense, and how it is usually carried out by an actual restraint of a person, by limiting his movements, and by his or her submission to the custody. And there are two modes in conducting an arrest: arrest by virtue of a warrant and arrest without a warrant. So what are the general guidelines surrounding an arrest? It should be made only based on a valid warrant of arrest, which is issued by a competent authority except in instances where the law allows warrantless arrest. Second, no violence or unnecessary force shall be used in making an arrest, and the person to be arrested shall not be subjected to any greater restraint than what is necessary under circumstances. Now, so I was mentioning the use of force is allowed to effect an arrest if the situation so requires, but it must be within reason. Right? However, this does not mean that an officer will afford the person to be arrested the opportunity for a fair or equal struggle. The successful arrest of the person is of primordial importance. Moreover, if a person is unarmed and does not present any threat, it would be illogical to apply lethal force. Now, using the concept of self-defense, so if you are an arresting officer, the use of a firearm as self-defense can be justified only if you face a real threat to your life. And the peril sought to be avoided, number one, must be actual, it must be present, dili pwede nga imo lang imagination or base lang sa imong interpretation. It must be actual, it must be imminent, right? It must be imminent in the sense na nakikita mo, right? Nakikita mo, there are overt acts. And by these overt acts, the things or the harm, the threat to your life which you fear is sure to happen. Right? So it must be actual, imminent, and real. So unlawful aggression should be present for self-defense to be considered as a justifying circumstance. Lastly, as I have mentioned, the police shall not use warning shots during police intervention operations. Or, let me rephrase the word, the police is not permitted to use warning shots during police intervention operations. Then, as a general rule, arrests can be made on any day of the week and at any time of the day or night. Only judges are authorized to issue warrants of arrest. And then, if the accused is already under detention, a warrant of arrest is no longer needed. Then, ano yung in lieu of warrant of arrest, we have the order of commitment issued by the judge in lieu of the warrant of arrest. Then, as for the territoriality of the arrest, we have already discussed this one. A warrant of arrest is enforceable only within the territory of the government or state issuing the warrant. Second, in a warrantless arrest, based on the commission of a crime, the crime must have been committed within the territory of the government or state whose agents are carrying out the arrest. Third, in an arrest based on a warrant of arrest, it is not essential that the arresting officer has the warrant in his possession at the time of the arrest. Example, on the concept of territoriality. Agent A of NBI is on vacation in Singapore. One night, he chanced upon Mr. Juan de la Cruz, and Mr. Juan de la Cruz has a standing warrant of arrest in the Philippines for a crime of rape. Take note on the first limitation of arrest on the concept of territoriality. As much as he would like to bring Juan to justice, he could not effect an arrest since the standing warrant of arrest is enforceable only within the Philippines. That's the first concept. For the second, likewise, although littering in Singapore is considered an offense, Agent A could not invoke warrantless arrest against Juan when he saw him throw his litter because the crime committed is against the Singaporean government only. Since Agent A is not an agent of authority of the Singaporean government, he does not have jurisdiction over the offense committed by Juan. All right? So, let us proceed with the immunity from arrest because I was not able to present this to you during our discussion. So, there are persons who are immune from arrest. And who are they? Under the 1987 Philippine Constitution, a senator or a member of the House of the Representatives while the Congress is in session for an offense punishable by not more than 6 years of imprisonment. So they are immune from arrest. Okay? What about yung kay Trillanes? Are you familiar doon sa kaso ng Trillanes? Hello.
Asa to sir katong ni adto sila sa hotel sir.
Yeah. Sa open meeting. Everybody from the class. That was rebellion, right? And it was during the time of Pinoy in which Trillanes was afforded of the so-called absolute pardon. Sorry. Not absolute pardon, but rather ka ng Congress? Wait I forgot. Yung there, merong concurrence by the state? I mean by the Congress?
Work amnesty maguro to sir.
Amnesty. Amnesty. Kaya kumbaga, pinatawad na sila ng state. Alright? So, they were forgiven by the state. Amnesty. But, di ba, during, under the Duterte administration, since Trillanes was a vocal critic, so, nagkaroon ng legal problems si Trillanes. And one of which is in-issue or question yung legality ng kaniyang amnesty. Tama? So, because of the reasons, the Solicitor General, I think, or I forgot the facts of the case, but it has been ruled out na kumbaga parang void yung kanyang amnestiya. And then,
Revoke.
yes, incidentally is nagpalabas ng warrant of arrest against sa kanya, right? So, because of that, is si Trillanes, if you can still remember, is nagtago siya doon sa Senate. Can you remember?
Yes sir, yes sir.
Yes. Now, can we apply the situation of Trillanes regarding the immunity? Since at that time he was a senator, can we apply the concept of immunity? Anybody? Gatman.
Kuan sir, if unsa ganito yung offense sir ni Trillanes rebellion?
Yeah.
If ay di ba ko familiar ng rebellion sir, unsay kanang penalty niya kanang say
Lagpas siya ng 6 years.
okay, so kana Senator Trillanes will former Senator Trillanes will dili ma-apply ang immunity sir because the offense which is rebellion is punishable by more than 6 years sir.
Aside from that, let us assume, Ms. Gatman, let us assume that the penalty have not exceeded 6 years.
Wala na exit na sa to sir?
Yeah.
Okay. So according to section 11 article 6, immunity from arrest could be applied if the offense is punishable by not more than 6 years of punishment. So sir, so pwede na to magamit ang immunity sir for senator or any member of the Congress.
But what happened to the case of Trillanes? Since beyond, nag-exceed siya og 6 years sa kanyang punishment, why was it that the arresting officer was unable to serve yung warrant of arrest kay former Senator Trillanes?
Di ba ko familiar aning case ni Trillanes sir?
Because they were not able to serve the warrant of arrest. Ms. Perez.
Yes, sir. Given the first situation kanina, sir, yung let's just say example, if Senator Trillanes nagtago siya. Actually, sir, given if ever less than 6 years po, yung immunity lang, the presence of immunity provided in section 11 is only applicable when the senator or the members of the House of Representatives or is in session, sir. And given na yung first example mo kanina, what if the imposition or penalty was less than 6 years? Therefore, pwede pa rin na like we can still issue the warrant, but provided that if ever mo exceed man galing sa 6 years imprisonment, they still need to give courtesy to the kanang Supreme Court sir ba where the session is taking place kay it's a matter of Congress ba ya, where judicial na siya nga kuan, so therefore it's not that easy na mo barge in ra ang arresting officer dito siguro sir to issue the outstanding warrant against Trillanes, even though provided siya na even though the punishment for rebellion again that's punishable sa Title 1 sa book 2 which is crimes against nation. So provided that one sir they can barge in, but maybe in that case not really sure sir because I'm not familiar with that case, but
Take note, Ms. Perez, the session or rather the Senate is, di ba, there is this parliamentary process na before the start, so the Speaker, the Senate President, will have to formally put the session open. And then he will have to put the session, kumbaga, arong parang i-dismiss na niya ang session. Tama?
mm-mm.
Yeah. So, normally, yung session will not last for days, right?
Yes sir.
Yes. So, the session will be, assuming, mag-start siya og 6 a.m. and then mag-end siya og 10 a.m. So, nga naman nga, still, they have not served yung warrant. Go back to your answer, Ms. Perez.
I thought, sir, nag-gather pa ko sa thoughts, sir. So, sorry, sir.
It was actually because, as mentioned by Ms. Perez, the courtesy for the Senate. So that was actually the reason. Although in fact, the Senate is not already in session, so the arresting officers have extended courtesy since that is the House of Senate, right? So what happened is it lasted for, I think, days, right? It lasted for days before Trillanes was siguro, I don't know, with the intervention of the Senate President, Tito Soto during that time. So he was, kumbaga, nag-usap-usap na lang sila na si Trillanes would voluntarily surrender. But what happened is the arresting officers were unable to serve yung warrant of arrest in courtesy or as a form of courtesy to the House of Senate. Alright? So that's what happened.
Dili ba to sa kuan sir? Dili ba to sa warrantless sir kanang si kuan rin nag-serve og warrant ba si Duterte? Wala sa mga korte sir ba? Mo wala dakpa si Trillanes.
Dili man siya warrantless to, kay na may standing warrant of arrest to sa iya.
Kung warrant bigyan po na sir basta ang presidente may mo serve sa warrant dili mo agi og pras kanang kuan sa korte sir. Judge like kana.
Unsa?
Like kanang ma-serve gyapon ang warrant sir o kanang ang presidente rin mo kuan sa warrant sir ba nga mo kuan sa mga pulis nga tagay warrant of arrest si Trillanes na wasla mo agi korte kini sir. Ay permahan sa judge.
Technically speaking, since yung since yung case ni former Senator Trillanes was number 1, rebellion, and then the punishment is more than 6 years. Second is that the Senate is not in session. So even if not without the intervention of the President, pwede to sila mag-serve of warrant of arrest. But then again, the arresting team, for purposes of extending courtesy to the Senate, so they were unable to effect the arrest. Alright? So that's what happened. But technically, they could have served the warrant of arrest because in the first place, Trillanes was not immune by virtue, or rather, if we are to consider the first circumstance or first instance of immunity from arrest. Can you follow, Mr. Gabutan?
Yes sir, thank you sir.
Right, thank you. Then, The second instance wherein the second instance for the with regards to the immunity from arrest is extended for our diplomatic agents. And who are our diplomatic agents?
Head of state, sir.
All right. Sino pa?
Ambassador, sir.
Yes, ambassador. Right? We are talking about ambassadors. They are what we consider, or rather, ambassadors, ito yung nare-refer natin dito sa diplomatic agents. So, technically speaking, they are immune from prosecution, from arrest by any person in any court of the Republic of the Philippines or by any judge or justice whereby the person of any ambassador or public minister of any foreign state, take note, he must be authorized and properly received as such by the president. Ito yung requirement. So, dapat authorized siya. Or of any domestic servant, of any, take note, domestic servant, of any such ambassador or minister is arrested or imprisoned, or his goods or chattels are distrained, seized, or attached, shall be deemed void. And every person by whom the same is obtained, or prosecutor, whether as a party or attorney, and every officer concerned in executing it, are penalized. This is by virtue of Section 4, Republic Act number 75. So again, sino yung immune from arrest? By virtue of the second circumstance. Ambassador, sino pa? Foreign minister, sino pa?
Diplomat, sir.
Diplomat, sino pa? Take note, andito yung domestic servant. Domestic servant ng ambassador. Right?
Assistant. Yes.
Then, yun. So, they will be immune from arrest. However, take note, students, that according to Republic Act number 75, for an ambassador or for a public minister or foreign minister to be immune from arrest, dapat ang country where he came from should have almost the same law. Parang dapat mutual siya. Should have the same law that will be, or should have the same law in which, in this particular law, same rights or same immunity will be given also to our Filipino ambassadors who are assigned in their country. Can you follow?
Yes, sir.
Yes. So that's what this particular provision is all about. However, take note, there is an exception. Under the generally accepted principles of international law, consuls, vice consuls, and other commercial representatives of foreign nations do not possess the status and cannot claim the privileges and immunities accorded to ambassadors and communities. Hence, a consul is not exempt from criminal prosecution for violation of the laws of the country where he resides. And yung kanyang jurisprudence is Schneckenberger versus Moran. Okay? So, this is the second circumstance wherein a person is immune from arrest. Again, who are immune from arrest? By virtue of 1987 Philippine Constitution, a senator or member of the House of the Representatives while Congress is in session for an offense punishable by not more than 6 years of imprisonment, and the diplomatic agents. Okay? So let us proceed now with the concept of warrant of arrest. Diba? What is a warrant of arrest? Why is there a need for a warrant in effecting an arrest? According to Section 1, Article 3, Bill of Rights of the 1987 Philippine Constitution, it have provided that no person shall be deprived of life, liberty. Take note, andyan yung liberty. Ito yung pinag-uusapan natin because if you arrest a person, you are restricting, you are restraining his movement. Hence, you are depriving him of his liberty. Okay? No person shall be deprived of life, liberty, or property without due process of law. So, it is in this particular provision where the need for legal grounds in the deprivation of a person's liberty is emphasized. Accordingly, one could not be deprived of his liberty for trivial reasons, kanang mga ginagmay or kanang mga walang kwentang reasons, and any other reasons that is not within the realm of law. Meaning to say, one should have a violation of a law for him or her to be arrested. Thus, the need for a warrant in effecting an arrest. According to Pamaran, Pamaran is sikat ito kasi naging during nung panahon ni Marcos is naging special prosecutor siya ng Sandigan Bayan. So, Pamaran added that since arrest involves curtailment or parang inaano natin yung kanyang basic natural right, so it is generally necessary that a warrant for the seizure of an individual be issued by the proper authority. So that is the main reason why we need a warrant in effecting an arrest. Let us proceed with the probable cause. So according to Vicente et al., 2016, probable cause refers to the evidence, right? Refers to the evidence that warrants a person of reasonable caution in the belief that a crime was committed. Now, take note that the question of whether probable cause exists or not depends upon the judgment and discretion of the judge or magistrate issuing the warrant. Take note, this, kumbaga, if we are to break down this particular provision, this particular sentence, means to say that the exclusive, okay, or rather, probable cause is exclusively determined by a judge only upon his judgment and discretion. So the question now is, paano siya makapag-arrive sa kanyang judgment at saka doon sa discretion? That's why, right? That's why dapat, or rather, before the issuance of a warrant of arrest, the persons who are applying, right, must present evidence to convince the judge. To convince the judge for him to arrive to his discretion or judgment, whether or not he will issue a warrant of arrest. Take note, take note, since probable cause yung pinag-uusapan natin dito, it does not necessarily mean that a specific or particular facts must exist in each particular case. It simply means that there are sufficient facts. Right? There are sufficient facts. There are enough facts. Take note of facts. When we speak of facts, proven to. Sufficient facts must be presented to the judge or magistrate issuing the warrant to convince him not that the particular person has committed the crime, but that there is a probable cause to believe that the person sought to be arrested committed the crime charge. So let us proceed with our illustrative example. For instance, A was killed. No? Upon investigation, Officer Juan de la Cruz discovered that A and B had physical altercation. Nag-away sila months before the incident. And then, Officer Juan de la Cruz have also obtained a CCTV footage showing B walking past the house of A moments before he was killed. Tapos, another facts, there were statements from witnesses. Kino-corroborate nila o pinapatotohanan nila that B has been suspiciously going back and forth A's house. Going back and forth A's house, and he was seen in a hurry carrying a blood-stained knife an hour later. Take note walang direkta na nakita doon sa krimen. Diba? There is no particular facts that will point that it was A, or rather it was B who killed A. What was being presented only, di ba, ito? So upon presentation of these facts and statements to Judge Cielo, a warrant of arrest was issued. So, what is the reason now? What is the rationale why a warrant of arrest was issued? The issuance was done since there are sufficient facts that convince the judge that A, take note, may have committed the crime, hence the need for him to be arrested. These facts are altercation between A and B, second, CCTV footage, and then the third, the witness's testimony na suspiciously going back and forth si A doon sa bahay, o si B doon sa bahay ni A, and then nakita siya na meron siyang daladala na duguan na knife an hour later. So yun. So that's how that's the concept for a probable cause. However, you have to take note that once the judge have arrived to his conclusion that a warrant of arrest should be issued, then that will be irrevocable. Take note, that will be irrevocable. So, sabi dito, the judge's determination as to whether there exists probable cause or not, after careful appreciation of proof presented, is irrevocable. Hindi na pwedeng bawiin. His conclusion is final and conclusive. This is according to People versus Ocampo. Judges, however, judges must strictly comply with the requirements for the issuance of warrants of arrest. Ano itong requirements na to? This includes, there must be the conduct of preliminary examination. Okay? There must be a conduct of preliminary examination. Ano yung preliminary examination na pinag-uusapan natin dito? Anybody from the class? Cantones. Ano yung preliminary examination na pinag-uusapan natin dito? Hello, Cantones? Are you there? Anybody? Miss Perez? recently?
Yes, sir. I think that's the in pursuant to anti-torture warning sa PNP, sir.
How come? How come?
Katong stated, sir, na, di ba, we have Miranda rights na it states there na you're arrested for the crime of blank. Yeah. You have the
Yeah.
right to remain silent. Any statement that you made may be used against you in any court of law in the Philippines. You have the right to have a competent and independent counsel, preferably of your own choice. And if you cannot afford services of counsel, the government will provide one for you. Then after that one, sir, the police officer will also inform them that the accused has the right to physical examination. If I can clearly remember it, that the statement are as follows: you have the right to demand physical examination by a competent and independent doctor, preferably of your own choice. And if you cannot afford the services of a doctor, the state shall provide one for you. So I think it's necessary also, sir, provided that there must be this proper or strict compliance to the constitutional provision na there shall be no unnecessary force given if a person is arrested. Kaya necessary na we have physical examination to really determine whether the person arrested was not employed with unnecessary force that could somehow vitiate his free will. Kasi it could somehow affect the person, man said, sir. So that is one of the basic constitutional rights of any person under custodial investigation, man said, sir, to demand physical examination. So if there are lapses between the law enforcement authority,
Ay, sorry.
that's a basic ground for dismissal at pwede ring makasuhan yung mga police officer because they had not observed the proper rights of the accused, sir. That's my opinion, sir.
Gatmin, you're raising your hand?
Yes, sir. In addition to what Miss Perez said, sir, when we say preliminary investigation, this is an
No. Preliminary examination.
preliminary examination.
Yeah.
Yes, sir. In simple terms, sir, preliminary examination is to ensure that there is no violation sa constitutional rights sa accuser. Muna siya, sir.
But take note, what we are talking right now is there is no warrant of arrest issued yet. The warrant of arrest has not been issued yet. Diba? What we are talking about now is the state of being irrevocable once the judge has issued a warrant of arrest. Diba? Kasi yung provision is, diba, ang sabi, once the judge has issued a warrant of arrest, all right, after careful appreciation of the proof presented, it is irrevocable. Yung kanyang determination, yung kanyang decision. His conclusion, accordingly, is final and exclusive. But, all right, there is a but. Diba? Although presumed regular, that's why, kumbaga, binibigyan, kumbaga, hindi pwede na questionin yung decision ng judge when it comes to the issuance of warrant of arrest. Dapat lang, or rather, considering na nag-issue na siya ng warrant of arrest, it is already irrevocable. It is already final and conclusive. However, ano yung safeguard? Since final and conclusive na yung determination, yung warrant of arrest na na-issue ni judge, ano yung magiging safeguard? Ano yung magiging protection ng isang normal citizen against the possible abuses na pwedeng makomit ng judge because of this parang presumption of regularity that is being afforded to them. Diba? That's the question now. So, aron mabalance, aron na ay safeguard ang isang normal citizen is mayroong requirement. Okay? Ang sabi dito, the judges, however, must comply strictly with the requirements for the issuance of arrest. So, ang follow-up question now is, ano itong tinatawag or what are these requirements na dapat makomply ni judge? Diba? Ano yung requirements na to? So, ang sabi dito, this includes the conduct of preliminary examination. So, that's my question now. What is this preliminary examination? Anybody from the class? Preliminary examination. What is this? Hello? Hello, hello. Andyan pa ba kayo? Preliminary examination. Hindi ito yung prelim exam na nasa school.
Yes, sir.
Preliminary examination. What is this preliminary examination?
Um,
Kasi yun na nga. Sige, sige. Miss Gabuya.
like mo na ang yung initial response sir sa report nga imong madawat sir. So kanang mo na imong i-verify nimo sir if ang crime jud kay nahitabo sir may nana to sir. Or imong identify
what
nga
will
na
happen?
victim or unsa.
What will happen? What will happen? Like, what will happen for the preliminary examination? Like, officer ako, judge, mag-apply mi warrant of arrest. O sige. Sige. These are the facts of the case. Okay, sige, isend ko na lang sa email mo yung warrant of arrest. Ganun ba 'yon?
No, sir.
Yeah, what will happen? What usually happens?
Could it be, sir, na he will try to like assess the facts that was presented, sir?
All right? Andyan na tayo. And then, ano pa?
About facts, then sufficient witnesses, sir, like statements and or complaints.
Yan. That's the thing. That's preliminary examination. Dapat, yung nag-a-apply must personally appear together with his or her witnesses before the judge. And once they have personally appeared before the judge, anong gagawin nila? The witnesses will have to provide their testimonies. That's an evidence. If there are another physical evidence na pwede maipakita sa judge, ipakita. That is preliminary examination. Ina-assess ni judge if there are sufficient facts. O simply speaking, dinidetermine ngayon ni judge whether or not there is a probable cause. Because accordingly, if hindi siya mag-undergo sa process, right? If the preliminary examination was conducted in violation of the rights of the accused, then the issued warrant of arrest is deemed null and void. Can you follow na? Di ba? So, meron ng safeguard. Kumbaga, meron tayong protection. Kasi, yung first na provision, the judge's determination as to whether there exists a probable cause or not after careful appreciation is irrevocable. His conclusion is final and conclusive. If we are to strictly follow this one, di ba? What if the judge is already abusing his power, di ba? Since irrevocable man, since final and conclusive, so what if nag-aabuso sa power yung judge? So therefore, to prevent that from happening, mayroon siyang safeguard to protect also ang rights kanang mga person. Diba? So that's why it must be proven nga dapat nag-conduct siya og preliminary examination. Meaning to say, yung arresting officer or yung warrant officer pumunta personally doon kay judge together with his or her witnesses and they have kumbaga presented kung ano man yung mga evidence, ano man yung mga facts So that is preliminary examination. So question, pwede ba siya na hindi siya personal?
No, sir?
No, pwede siya. Exceptional circumstances. Number one, there is a public health emergency.
Sir, COVID di
Oh,
ay.
di ba?
Sir. Sir.
Di ba? COVID, di ba? Katang na ay COVID. Oh, do not tell me na walay mo dili mo issue ang judge of warrant of arrest kay dili personal, di ba?
Ay,
Pwede
kato
siya.
online, sir. Katong mag-meeting.
Pwede. Pwede. Di ba? What is being kumbaga, as a general rule, should personally appear. Pero in cases wherein kumbaga merong mga exceptional circumstances or exigent circumstances, din pwede. Di ba? And yung public health emergency, that is one of an exigent circumstance naman. So pwede siya. Tama?
Yes, sir.
Okay, for a while lang ha, for a while. Alright, going back. So, yun na. So, if there is a violation or no preliminary examination have been conducted and then a warrant of arrest has been issued, then it will be considered null and void. Ang jurisprudence nito is Calyanta versus Inahe 117 is CRA 56. Okay? The reason kung bakit included ito is you can check this online for references ninyo. Pwede nyong basahin yung buo. At least digested na siya para at least
Ang sa to, sir?
naamay mga kanang mga jurisdiction ba. Calyanta versus Inahe 117 is CRA 56. So try to research that one lang para at least yung facts of the case surrounding dito sa case na to is malaman nyo, and then you'll be able to appreciate yung ruling. Because itong pre-present ko sa inyo, these are already rulings by the Supreme Court. Alright? These are already rulings by the Supreme Court. So going back, it was ruled that a warrant of arrest, ito another, you have to take note also of this one. So, who will issue warrant of arrest? Exclusive? Hello? Who will issue? Who has the exclusive power to issue warrant of arrest? Judge. And ano yung basis for the issuance of a warrant of arrest?
Probable cause, sir.
Yes. Take note of that. It must be only issued upon probable cause. So therefore, if a warrant of arrest was issued based only on the prosecution's findings and recommendation, like the information or resolution finding a probable cause, right? Without the court determining on its own the issue of probable cause based on evidence like the complaints, affidavits, counter affidavits, sworn statements of witnesses, or transcripts of stenographic notes, if any, it shall be considered null and void. Take note, it boils down to the fact that the judge has the kumbaga exclusive power to issue doon sa warrant of arrest. And it must not be based on the prosecutor kung ano yung recommendation siya, but rather dapat yun na nga, yung preliminary examination. Dapat yung court
Nation.
mismo or yung judge mismo ang magde-determine doon sa probable cause, not the prosecutor. Can you follow?
Yes, sir.
Yes, sir.
Mhm. And then ito. Lastly, the warrant must particularly describe the person to be seized. Take note, particularly describe to be the person to be seized. Meaning to say, included yung kanyang name, yung kanyang address. Included yan. This is essential to the validity of the warrant that the person to be arrested should be identified by the terms of the warrant. Whenever possible, therefore, the name and description of the person to be served with a warrant must be inserted in it. Now, where the name is unknown, the warrant must contain a description that will enable the officer to identify the person to be served. So, even if it does not contain the name of the defendant or rather, if the warrant does not contain the name of the defendant or any description or designation by which it could be known and identified as the person sought, it is void. Can you follow? So meaning to say, di ba, yung the warrant must particularly describe the person to be seized. So ano yung requirements para ma-fulfill natin itong itong provision na ito? So dapat daw is properly identified yung person. And how do we achieve that? Meaning to say, dapat andun yung kanya, or rather, whenever possible, included or inilalagay natin doon sa warrant ang kanyang pangalan. Okay? Ilalagay natin doon yung kanyang pangalan. At saka, yung ano pa yung isa?
Address, sir.
Aside from that, no. Yung name, dito lang tayo dito. Dito lang tayo. Huwag tayong lalayo.
Yung place, sir.
No. Huwag tayong lalayo. Balik tayo dito sa module. Yung lastly, the warrant must particularly describe the person to be seized. What must be contained doon sa warrant? Name and the
Description.
description. Very good. Name at saka description. Ito yung
Description.
requirement. Ito yung requirements para masatisfy natin itong provision na ito. So meaning to say, either of these two. Can you follow? Either of these
Yes,
two.
sir.
So meaning to say, so pwede ang nakalagay dyan is yung or rather, whenever possible daw, yung name at saka yung description. Sir, what about if name lang, walang description?
Dili, pwede, sir.
Either mga
Imposible na walang description. Imposible na walang description kasi nga syempre under investigation, 'di ba? You need to hindi pwedeng pangalan lang. Si
Audit,
Sharon
sir.
Reyes, pero you have not particularly seen or you have not particularly observed whatever the description of that person. It is impossible, 'di ba? Pwede meron kayong description pero hindi nyo alam kung ano yung totoong pangalan. Pwede yan. Can you follow? So, walang description or rather, merong description pero walang pangalan, pwede yan. Pero, walang pangalan, walang description, hindi pwede. Okay tayo dyan?
Yes, sir.
Mhm. Punta tayo sa question na to. What about daw if the identity of the person to be arrested is not fully established? Diba? So, it has been settled na even though walang pangalan, basta merong description, pwede mag-issue ng warrant of arrest. And that is what we call as John Doe warrant. Right? So accordingly, a warrant issued upon a named party is called John Doe warrant. It is necessary that the party should be sufficiently identified. Take note kahit walang pangalan, he or she must be sufficiently such identified. Such a warrant must contain the best description personae or the description of the person to be apprehended. And this description must be sufficient to indicate the proper person upon whom the warrant is to be served. Okay? It should likewise state his personal circumstances, appearance and peculiarities, give his occupation, place of residence, and any other circumstances by means of which he can be identified. Okay? So, now, a warrant which describes the person to be arrested as mere John Doe or Richard Doe is void unless there is a further description of the description personae as will justify an officer to act under it. Or simply speaking, if your description personae is pangalan lang yung ibinigay mo or hindi mo na-establish yung pangalan, John Doe o Richard Doe lang, tapos walang description personae, then void yung warrant of arrest. Can you follow?
Yes, sir.
Do you have questions so far or clarification?
None so far, sir.
All right, thank you. Ito, another question. When is arrest not necessary? Ba? Kailan ba hindi na, or rather, ano ba yung mga circumstances or circumstance wherein hindi na kailangang mag-conduct ng arrest? When the accused voluntarily appears after a complaint. Merong reklamo after a complaint in a criminal action is filed against him. And then nagbigay siya ng bond for his appearance at any time he may be called, no arrest is necessary. So voluntary appearance relieves the necessity for an actual arrest. Take note wala pang warrant of arrest na in-issue. Upon complaint pa lang, nireklamo pa lang siya, the accused have voluntarily appeared, and then nagbigay siya ng assurance na anytime magpapakita siya in the form of a bond, okay, bond, then no arrest is necessary. Ito yung ano natin, for the period of warrant of arrest. 10 days, di ba? The head of the office to whom the warrant of arrest has been delivered for implementation shall cause the warrant to be implemented within 10 days from receipt. Now, within 10 days after the expiration of such period, the police officer or the warrant officer, PNP or NBI member holds a warrant for execution to whom it was assigned for implementation shall make a report to the judge who issued the warrant, and in case of his failure to implement the same, shall state the reasons thereof. This is according to section 4, Rule 113 Rules of Court. Now, ito yung inuulit-ulit ko sa inyo. What is the rationale behind the 10-day period? So the purpose of this provision is to remedy the problem on the indifference of officers in serving warrant of arrests, thus leading to delay in the disposition of criminal cases. This can be attributed to the former rule on the same matter. There was no provision for a definite period within which the warrant must be executed, nor did the old rule impose upon the officer tasked with the execution of the warrant the duty of making the corresponding return within a definite time span and of apprising or informing the judge of the reasons why the warrant could not be served if such be the facts. So, this must be so. For the return mentioned in the section refers not to the physical delivery of the very same copy of the process to the issuing court, but to the report of the officer charged with its execution and the action taken by him thereon. This is according to Pamaran. So, in short, the 10-day provided in the aforementioned section is only a directive to the officer executing the warrant to make a return to the court. So, even if not served within the statutory period, the warrant of arrest remains valid. Ito yung inuulit-ulit ko sa inyo, whether or not a warrant of arrest has an expiration. This is the rationale doon sa 10-day period. So, it remains valid unless the warrant was recalled by the issuing court, he or she was already arrested, the respondent voluntarily submitted himself or herself, the respondent died. Okay? So, that is the rationale behind the 10-day period. The very main purpose is not to set yung initial expiration, but only to enjoin the police officers that if ever or in circumstances wherein they will be unsuccessful, they are unable to serve the warrant of arrest, they will have to return and make a report to the issuing judge or court. Ito, I have to highlight this one also. When women or children are among the arrested suspects, the arresting officer shall task the Women's and Children's Protection Desks officer or WCPD officer or a policewoman who is familiar with women and children protection desk duties to conduct the pat-down search. Okay? Yan pa. Ito. If the person arrested waives his right against self-incrimination, di ba? Meron tayo, ano ulit yung mga rights of a person arrested? Yung sinabi mo kanina, Miss Perez?
The right to remain silent, sir.
Yan,
The right
very good.
to have a competent counsel or
Sige,
demand a
Sige,
physical,
iyan lang muna.
physical.
Iyan lang muna. Di ba? The right to remain silent. Tama? Because anything he or she says can and will be used against him in the court of law. Tama? So, ito yung pinag-uusapan natin dito na right against self-incrimination. That's why during arrest, ini-inform ka na you have the right na hindi sagutin yung mga tanong. You have the right to remain silent. So what will happen na? What if? Diba? What if? In-apprise mo na siya. Sir, you have the right to remain silent. And then, kumbaga, winave niya Winave niya. Hindi niya ginamit itong right na ito. And then he chose to give his statement. Okay? So, ano yung safeguard to ensure na magiging valid yung statement niya? Can you follow? Di ba? So, what shall you do if you are the arresting officer? You shall ensure that the waiver is made in writing. Hindi pwedeng verbal consent lang. It should be black and white. It should be made in writing. Tapos, dapat meron signature. Tapos, although in writing siya, meron signature, but not within the presence of a counsel of his own choice or a competent, then it shall be deemed null and void pa rin. So, dapat present itong tatlong requirements na to. Number 1, the waiver must be in writing. It must be signed by the person who have been arrested, and it must be within the presence of a counsel of his own choice. Take note, right against self-incrimination. Yung sinabi mo kanina, Miss Perez, ano ulit yung tawag doon? Yung mga rights?
Miranda rights, sir.
Miranda rights or Miranda doctrine or Miranda warning. Tama?
Sir. Yes, sir.
Yan. Are you familiar with the history of Miranda doctrine?
Gamay, sir.
Sige,
Miranda versus Arizona, bato na, sir?
Tapos?
Wherein Miranda constantly the arresting officer, sir, kay nag-ask siya og self-incriminating questions, sir, and then Miranda, without being informed that he has the right to be silent, sir, admitted or give his statement, and then that police officers tried to use this in court, and then ang defense like the defense of the attorney was that he was not informed, or like wala siya na-inform nga he has this right against self-incrimination, that he cannot be compelled to be a witness against himself. So therefore, the ruling was that i-void ang katong inadmissible to because it is a fruit of the poisonous tree. It was not legally obtained because the person arrested was not informed of his basic constitutional right to remain silent, sir, when arrested.
Yeah, that's the main reason. And then, the Constitution have ruled out na dapat in making arrest, dapat i-inform. Kumbaga, yung Miranda versus Arizona case, ito yung naging reason kung bakit ngayon, nowadays, yung mga police is, kumbaga, inuutusan sila or required sila na when making an arrest is they have to inform yung basic constitutional rights of that arrested person. Diba? Ganun yung nangyari. Okay? Moving on. Ito yung authority ng isang arresting officer kapag nagkakandak siya ng arrest. So, when you are a police officer, you are allowed by the law to summon assistance. A police officer making a lawful arrest may verbally summon as many persons as he deems necessary to assist him in effecting the arrest. Medyo familiar yung concept?
Yes, sir.
Anong concept ito? Sa law enforcement organization and administration na subject ninyo?
Citizens arrest, sir?
Nope. A police officer may summon assistance. Are you familiar with the Watch and Ward Act?
Yes, sir.
Oh. Ano
Yes, sir.
yung defining feature or defining characteristics ng Watch and Ward Act? Yung Watch and Ward system, andyan yung assize of arms, ano pa? Ano pa yung highlight ng Watch and Ward?
Katutang UN cry, sir.
Yes, you and cry system, di ba? Yung if you are the watch or if you are a ward and then meron kang hinahabol, so pwede kang mag-summon ng assistance coming from the citizenry, di ba? So ito yung konsepto na to. A police officer making a lawful arrest may verbally summon as many persons as he deems necessary to assist him in effecting the arrest. And then, ito, naitanong ko ito. Sino ba yung naitanong na ano ko dito? Sino ba yon? Sino ba yung naka-ano ng question nito?
About the right to break out, sir.
Ikaw ba yon, Miss Cantones?
Dili, sir. Si Kuan siguro to, sir. Camarines.
Oh, si Camarines. Wala siya ngayon? Murag nakita ko to siya kaniya. Wala.
Wala, sir, wala.
Di ba? So, the question was, you have a warrant of arrest. And then, isa-serve mo na siya. And then, it so happened na nung nandun ka na is you were denied entry. So, what will you do? Di ba? Do not tell me na, oh, balik na lang ako bukas. No. Di ba? Andun ka na eh. Meron kang warrant of arrest. You have a lawful order. Tama? You have a lawful order. So therefore, as a police officer, you are given the right. Gitagaan kag sa may Bisaya sa right?
Katungod, sir.
Katungod? Katungod gyapon. Kay sa amo, sa waray-waray, katungod gyapon. So gitagaan kag katungod nga pwede kag mag-break into building or enclosure. A police officer, in order to make an arrest, with or without a warrant, may break into building or enclosure where the person to be arrested is or is reasonably believed to be if he is refused, take note if he is refused admittance. Right? If he is refused admittance. Ano bang ibig sabihin nito? Anybody from the class? Hello?
Wala gipasulod, sir.
Wala gipasulod. Anong implications niya? What if walang tao? Nandun kayo, walang sumasagot. Will that constitute refusal of entry or refusal of admittance?
No, sir.
No, sir.
No, sir. Kaya may tao, sir.
Kaya wala may tao.
Yun. You have to take note of that, Kasi baka mamaya, hindi kasi kami nagpunta kami doon, tapos walang sumasagot, kaya nag-break in ako. You have to be mindful of that kasi ang sabi if refused admittance after announcing his authority and purpose. Can you follow? If you believe na merong tao, so normally naman, pag magsaserve ka ng warrant is normally na-akay intel, tama?
Yes, sir.
Diba? Hindi ka magpupunta doon kung hindi mo alam kung ano yung pupuntahan mo, tama?
Yes, sir.
Yes, sir.
Ito kasi yung common. Ito yung common na mistake ng isang warrant officer. There was this instance dito sa Samar. Magsuserve siya ng warrant of arrest. And then, yung lugar is critical. Alam mo yung kung ano yung ginawa ng police? Mag-isa lang siya na pumunta doon. What happened? Napatay siya. Di ba? Poor discretion on his part. Poor discretion. Alam niya na critical yung lugar, bakit isa lang siya na pumunta doon. Another instance, the same pa rin, sa Samar pa rin. Di ba? Sa Samar pa rin. Magsiserve din sila ng arrest warrant. Alright? Magsiserve sila ng arrest warrant. Pumunta sila doon, critical na oras. Critical na oras. What happened? They were ambushed. Di ba? So meaning to say, you need to have a good intel. You need to have a good intel. If you are to serve a warrant of arrest, particularly if critical yung lugar, you need to have a good intel. So dito, yung provision na ito, na right of a police officer to break into building is, as I was saying, after announcing your authority and purpose, and then you were refused admittance. Say, for example, mga pulis kami, nandito kami, upang magano ng warrant. And then, nakabatik kag na ay parang movement doon sa loob. So meaning to say, merong tao, tama? Oh.
Yes, sir.
Tapos, despite the fact na inulit mo, hindi pa rin kayo pinagbuksan, then that will constitute yung refusal of admittance. Then, you now have the right to break into that particular building or enclosure. Then, what about if nandun kayo sa loob? Tapos, kumbaga building, tapos yung pinag-anohan ng is parang na-trap ka or basta parang anything while inside ka na doon sa building. You have the right also to break out from the building. Yung una, pagpasok sa building. Pangalawa, para makalabas ka doon sa building or enclosure, you also have the right to break out. Sirain mo yung pinto, sirain mo yung bintana, ayan yung ibig sabihin dyan. Okay? Then, arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue to retake him without a warrant at any time and in any place within the Philippines. Ito yung citizen's arrest na pinag-uusapan natin. Alright. So, punta tayo dito. Do you have questions so far?
None, sir.
No, sir.
What about the others?
None so far, sir.
Si Miss De Pedro, baka may tanong.
None, sir. Wala na, sir.
Si Sir Mr. Isidro.
Wala rin, sir.
Si Lloyd Coronel.
Wala, sir.
Oh. So, okay man sa, klaro man ta atong presentation, no? Klaro atong discussion. So, let us proceed now to warrantless arrest. To the concept of warrantless arrest. Kasi I just want to really make sure na klaro tayo dito. The first instance, ito yung exceptional circumstances when in his or her presence, the person to be arrested has committed. Nangyayari, or rather, katatapos lang, tapos na, is actually committing, nangyayari, or is attempting. Take note sa attempting to commit an offense, ha? Dito sa attempting to commit an offense, there should be overt acts. Okay? There should be overt acts. Hindi pwede na wala pang overt acts. So, according to Pamaran, an offense is committed in the presence or within the view of the person making the arrest. Ano yung mga circumstances? When he sees the offense, kapag nakita daw niya yung commission, although at a distance, kahit sa medyo malayo. Okay? Or although at a distance, or pwede hindi niya mismo nakita, he just only heard the disturbances created thereby. And then he has immediately proceeded at once to the scene thereof. Okay? So ito yung offense has committed, or the offense is continuing or has been consummated at the time of the arrest is made. So iyan yung ibig sabihin ng when in his or her presence. Tapos, ano yung implications niya? Because of this ruling, yung arrest is valid when the person arrested was caught in flagrante delicto, is actually committing. So, pwede kang mag-apply or pwede kang mag-effect ng warrantless arrest. The arrest is valid when the person arrested was caught in flagrante delicto conducting an illegal cockfight, or when the accused was caught in flagrante selling marijuana. Ito pa ha. Similarly, when the person to be arrested had commenced, nag-umpisa na siya, had commenced the commission of the crime directly by overt acts, nakikita, overt, as when, kagaya ng, saan na ba yan? Wait sa, say for example, meron na siyang tinanggal na plyboard, and then he has already unfastened it in order for him to gain entry into a building. So, overt acts, his arrest without a warrant for attempted. Take note ha. Overt acts, attempt pa lang, although magnanakaw siya, pero ang nakita mo lang is tinatanggal pa lang niya yung jealousies or whatever it is aron makasud siya sa balay, then hindi yan attempted robbery ha? Can you follow?
Yes, sir.
Yes, sir.
Kasi nga, yung nakita mo lang is yun, kumbaga tinatanggal lang niya yung jealousy. So ang applicable diyan is trespass or attempted trespass to dwelling. Can you follow? Okay. Now, with regards to subversion, ito, subversion. Since continuing offense daw siya, subversion being a continuing offense, the arrest of the accused who is a member of the New People's Army without a warrant is justified, as it can then be said that he was committing an offense when he was arrested. Also, an arrest made after entrapment does not require a warrant inasmuch as it is considered a valid warrantless arrest. Yung tinatawag na entrapment. Now, what is entrapment? Anybody from the class? What is entrapment? Don't you have any idea what entrapment is?
Con, sir, one of its forms, sir, kanang ginatawag nato na buy-bust operation, sir.
Yeah. Buy bust is a form of an entrapment operation. Right? But, wait lang ha, kasi nakalimutan ko yung isa. Wait lang. There is a big difference between entrapment and inducement. Okay? There is a difference between inducement and entrapment. What is the difference? Wait sa. Oh, yun.
Sir,
So,
is
one form of entrapment is by bust operation, and this is a form of a warrantless arrest. So, it has been ruled that a warrantless or a by bust operation is constitutional because prior to it being considered constitutional, there have been complaints, there have been legal concerns na ang entrapment daw or by bust operation is unconstitutional. But kumbaga, it has been ruled by the Supreme Court that a by bust operation is legal in the sense, provided that there is no intervention on the part of the law enforcement officer arresting or conducting the by bust operation. And what do we mean by the word intervention? This is where the question as to what is the difference between an entrapment and inducement comes. Why? Because sa entrapment is there is no active effort on the part of the arresting officer na parang pinipilit niya na mag-commit ng unlawful act yung yung person to be arrested. So kumbaga sa by bust operation is natural or walang intervention. Hindi natin siya pinwersa, hindi natin siya ano ba yung utos sa Bisaya?
sugo.
Sir.
Dili siya gisugo nga mag-commit of unlawful act. So on his own volition lang yon, on his own decision niya. Di ba? So what is sa by bust? Normally, pag makonsume na yung act, that's the time na magpakilala na yung arresting officer. At saka huliin na yung pag makonsume na. Di ba? Whereas sa inducement kasi is ibang usapan yun. What is an example of an inducement? Say for example, ako, pulis ako. And then, si A or si Juan, isa siyang kilalang tulak. Isa siyang kilalang tulak dito sa lugar namin. Tapos, ninapitan ko si Juan. Juan, naaba kay marijuana din na. Meron ka bang marijuana dyan? Sure, wala ako niyan eh. Wala. Sige na, mag-produce ka ng diba? Mag-produce ka ng marijuana, kung hindi, huhulihin kita. Para ano ni mo, sir? Sige lang, kay na ako'y kuhan. Diba? Kung dili ka mag-produce karon ng marijuana, takpunta ka. Kasuhan ta ka. So, si Juan, out of fear, Ni-headlock man siya, right? So, nag-produce siya og marijuana. Nya, upon giving yung marijuana kay police officer sa akin is hinuli ko si Juan. Hinuli ko siya. Possession of illegal drugs. So yan yung tinatawag na inducement. And that is a violation. Kasi nga, yung pag-produce ni Juan is kumbaga, just that particular act is there has been an intervention coming from me. So hindi yung act is not according to his own decision, not according to his own volition. Merong outside interference. So that's the difference between entrapment and inducement. Okay? So, yun. Klaro tayo dyan? Or may concern? Anybody? May concern?
Wala, sir. Wala, sir.
Sa iba?
Wala ra, sir.
Basin?
Wala rin, sir.
What
Basin?
if gano'n ko, sir, ang ikuhan sa pulis, sir?
Ha?
Ang gun, sir, dili ang marijuana, sir.
Come again, Mr. Marcos, kay dili maklaro ang mong audio.
What if hostil siya, sir?
What if?
Hostil.
Pusil? Pusil?
Oh, sir. Oh, sir.
What if pusil? Tapos same gihapon na ay interference coming doon sa ano? That is still inducement. Oh, no, I cannot. What is your question?
Okay na, sir.
No. Ayaw wag kay dili na ko makompleto pa kasi ang picture eh. That's why I have asked you kung ano ba yung question mo. So I want complete details. Sige na, Mr. Marcos, wag kang mahiya. President yung uncle mo ngayon eh. Ba't ka mahihiya?
Sir, what if, sir, I think money yang give us about, sir. What if a police officer, ba, like Intel, will ask somebody na you have a gun na magbaligya of illegal na gun ba? Could it be considered
Dili maklaro, Miss Perez. Otro.
about ano, sir? Klaro na?
Yeah.
Okay, sir. So I think Mr. Marcos' question, sir, is what if the police officer, sir, ba, is like, for example, he was an intel, then he was just asking somebody out of the blue na, do you sell guns? Tapos walang idea yung certain person nag-question, sir, if he is a police officer or not. Tapos, ano siya, na ako'y gun, na-obtain na ako sa kani nakoy baligya nga illegal gun, pero si police officer mismo nakutana, sir, could it be considered entrapment, sir, or inducement?
Entrapment. Kaya in the first place, there is no interference. Di ba? Wala siyang inano kay na mag-produce ng ganito. Ang question nyo or ang situation nyo is nagtatanong siya kung mayroong gun, kung naipusil. Unya, ang suspect is, ang iyang pag-assume is dili pulis ang iyang katransact kay Intelman. So, in the first place, ang suspect is nag-assume siya na regular customer. So, since nag-assume siya na regular customer, so nag-produce siya og pusil. Gihatag niya kay Intel. So, walang interference, walang intervention coming from police officer. So, that is entrapment.
Okay, sir. Thank you, sir.
Yes. Because that's actually the common occurrence sa entrapment, particularly sa drug by bust, di ba? Intel, undercover yung katansact nila. Hindi alam ni pusher na Intel na pala yung katransact niya. So, it always starts with a test buy. Alam niyo yung test buy?
Yes, sir. Yes, sir.
Yeah, mag-test buy muna. Mag-test buy muna, mag-test buy siya, tapos pag makakuha siya doon sa suspect is positive. Di ba? Na-establish na ninyo yung facts na nagbebenta siya ng illegal na droga. Alright, so what will happen now is entrapment na. The concept of in flagrante delicto. Caught in the act siya. That's why warrantless arrest siya. Di ba?
Sir, ako yung answer ba?
Okay.
Sige, Mr. Boy.
Like, what if nahitabo ang inducement, sir? Like, duhara ang nakabalo niya, verbal pa dito, sir. Nya, while kanang gidakop na siya, sir, walay nakabalo, sir. Ang katurang mismong polis nga, iyang ni kuan niya bitaw, sir, ni istorya nga, kuan, abot sa drugs, yung example, bitaw nakaon na. Nya, unsaon man na, pag kanahatag sa ebidensya, ana, sir, nga, inosente itong nagkuan, kay napupos sa to siya.
Alright. In the first place, nga naman nga gikuyog, nga naman nga nikuyog ka.
Awit.
Miss Gaboya, nga naman nga nikuyog ka. Kabalo ka nga illegal ang gibuhatan. Nga naman nga nikuyog ka.
Sige, nahadlok man siya sa polis, sir.
Hmm? Kay ang dili man ikaw ang original nga gikastorya sa pulis, tama?
Dili siya, mao jud mismo, sir. Like, original jud, sir.
Mhm. Tapos,
Nga, for example, di ba tayo magiging tupid na kontak?
ay,
Oras na
wait na, Miss Gaboya. Kasi,
Ha?
kasi yung audio mo is parang may ano, I don't know kung what's the reason. Basta hindi masyadong klaro yung audio mo. Are you
20, sir.
basig dool ka sa TV or sa any other gadgets? Mao nga
Sir.
murag wala ba? The same sa inyo?
Layo, wala ra jud, sir. Ako ra diri sa man.
Mm. Sige, so what you are asking is straight to the point na, Miss Gaboya.
Tan ako, sir, ba na unsaon kanang unsa ikang kanang i-prove ba nga innocent siya atong matter kay napugos naman siya sa police kay nahitabo ang inducement, sir ba.
Okay. Kung unsay buhaton katong suspetsado nga nadakop sa inducement, then you'll just have to
Oo,
prove.
sir.
You'll just have to prove. You'll just have to give your testimony regarding that one. Yan yung ano dyan. Yan yung challenge dyan. You'll have to prove that there have been an inducement. Number one. Diba? Number one is normally yung mga police officers natin to avoid yung misconception or to avoid the doubt na possible there has been an inducement is in order to address that, I think in my own personal opinion is number one, di ba, nagkaroon ng test buy, di ba? That's the reason kung bakit ginagawa yung test buy. Number two, aron dili mo maging doubtful nga naay inducement, yung transactions ninyo through text or through tawag, so pwede yan. So if you are at the receiving end, then pwede mong gamitin yun. Pwede mong ano yung mga ano, aron ma-prove nimo na dili entrapment but rather inducement ang nangyari. Can you follow, Miss Gabuya? Hopefully I have answered your question. Inducement. Kanang parang ginpipirit ka ba? Ibala ito. Miss Gabuya, have I answered your question?
Oo, okay na, sir.
Hopefully I have answered your question. Or maybe some of your classmates has a better idea? Anybody from the class? Miss Gatmin?
Your explanation, sir, is okay, sir, pero pwede ko manguta na, sir?
Sige, sige. Ayaw lang parting kwarta, ha?
Ay, okay na, sir. Sa'yo na dyan kayo ni, sir. Nagkuhan lang may. Kaning, is inducement, sir, same with the word
Oh, no,
instigation?
sorry. Yun. Sorry, I'm sorry. Kasi
Sige, sir.
instigation, the term. That's the term. Instigation. I'm sorry. I'm really sorry. Instigation between entrapment. Instigation. Hindi, ang inducement is almost the same thing with an instigation. Ini-induce mo siya.
Yes, sir. They are the same naman, sir.
Sige, Miss Gatmin, continue your question.
Mora to, sir. Nagkuhan ako, sir, kay ang sa criminal law, mga mga subject, sir, is entrapment versus instigation. So,
Yeah. Kasi yun lang nakalimutan ko. Instigation pala yung proper term. Sorry. Any other concern? Or question?
No, sir.
Answer.
Sige. Wait sa. Punta tayo sa doctrine of hot pursuit. Ito yung Consistent with this provision, the Supreme Court held the validity of the warrantless arrest of a person who was named by the victim as his assailant bago siya mamatay, just before he expired. Okay? So, pwede yan. Pasok yan. Warrantless of arrest by virtue of the doctrine of hot pursuit. Then, the same result was reached in a case where, on the basis of the testimony of two witnesses, the suspect was arrested the day following the murder. All right? Then, lastly, there must now be a large measure of immediacy. That it should be immediate. There must now be a large measure of immediacy between the time of the offense was committed and the time of the arrest. Why? Because if there be an appreciable time lapse, masyadong malaki na yung time lapse, 1 month after the commission of the offense, hindi ka pwede makapag-conduct ng warrantless arrest. 2 months, 2 weeks, that is already parang masyadong malaki na yung time lapse or gap. If there be an appreciable time lapse between the arrest and the commission of the crime, a warrant of arrest must be secured already. Dili na pwede nimo i-invoke ang doctrine of hot pursuit. Okay? So, yan yung rationale niya or explanation niya. Next, when the person to be arrested is an escapee, this right of arrest without a warrant of arrest under this provision is founded. It is based on the principle that at the time of the arrest, yung escapee, yung tao na tumakas, is in the continuous act of committing a crime. Can you follow? He is in the continuous act of committing a crime. Balik tayo doon sa unang provision. Ba? When in his or her presence, the person to be arrested has committed is actually committing. So that's the reason kung bakit if the person is an escapee, even without warrant, pwede natin siyang i-arrest. Because during that time na inaresto mo siya, he is in the process of, or rather, he is in the continuous act of committing a crime. Ano yung crime niya? Evasion of service of sentence. Nag-evade man siya, nagtakas man siya. So, yun. So, that's the reason, ha? That is according to Paraluman versus Director of Prisons. Then, or rather thus, if a convicted felon escapes from prison, he has no right to demand that he who arrests him be armed with a warrant of arrest. A convict who evades the service of his sentence, escaping from the surveillance of a policeman or from a penal institution, can be arrested without a warrant, not only by an agent of authority, but also by a private person. Okay? The same rule governs the arrest of detention prisoners. Even detention prisoner ka pala, dili ka pa convicted. Detention, nasa detention ka pa lang, who escape from confinement. So, ito yung mga common dito. Moving forward, physical examination of arrested suspect. So, before interrogation, take note, before interrogation, the person shall have the right to be informed of his right to demand physical examination by an independent and competent doctor of his own choice. If he cannot afford the services of a doctor of his own choice, he shall be provided by the state, so on and blah blah. Now, if the person arrested is female, she shall be attended to preferably by a female doctor. Take note, andyan yung word na preferably, because there will be an instance wherein ang doktor is dili babae. Okay? So, preferably lang. Not at all times babae. But, kumbaga, hindi siya nire-require na babae dapat yung tumingin. So, if dili available ang babae nga doktor, so pwede ang lalaki nga doktor. Then, ito pa, obstruction of attorney's right, punishable. Under the law, any public officer or employee who shall obstruct, prohibit, or otherwise prevent an attorney entitled to practice in the courts of the Philippines from visiting and conferring, makipag-usap privately with a person arrested at any hour of the day take note in urgent cases of the night, said visit and conference being requested by the person arrested or by another acting in his behalf shall be punished by arresto mayor. Then, visit of relatives. So, naagihapon right, a person detained in jail for the commission of an offense is generally at a great disadvantage, especially where affluent circumstances and influential friends are lacking. So, owing to his detention, he can neither by himself post the required bail, even if he could afford it, because he has nobody to arrange for one, nor engage the services of a counsel of his choice, for he may not have the means to communicate with him, nor confer with his witnesses, who ordinarily cannot be expected to see him in prison. So also, during the period of detention, the arrested person's next of kin are fraught with worries about his health and safety. So moved by these considerations, the framers of the rules thought it wise and fair to give the relatives of the arrested person the right to visit him at any reasonable time of the day and in urgent cases of the night, subject of course to reasonable regulations. So hindi absolute yung right na ito, because siyempre, assuming yung ngayon mayroong pandemya, so they cannot visit. Bawal silang magbisita doon. Another thing, mayroong nangyari doon sa loob. Say, for example, nagkaroon ng greyhounds tapos maraming mga illegal weapons na nakuha. So pwede na i-defer muna yung visiting rights ng relatives. Ano pa? Say for example, kasi may nangyari ito dito sa amin, sa Leyte Provincial Jail. Nung una, pwedeng magbisita yung relatives, particularly yung bata. What happened is, ang tatay maoy priso. Nya, ang nanay mo bisita. Kuyog ang anak. I think ang bata is 4 years old or 3 years old. Now, what happened is poor na yung mental health ng nung lalaki, yung detainee. What happened was naa siya'y kutsara. Kutsara mangguro gyapon no sa inyo. Spoon ba?
Yes, sir.
Kutsara. Naay kutsara. Yeah. Ang kutsara, ang yung gilid, ano ba yung gilid sa Bisaya?
Kilid, sir.
Yung kilid is, di ba kada mga stainless na mga kutsara?
Yes, sir.
Hopefully you can follow. Yung mga stainless na kutsara is, normally yung kilid niyan is ilahang gi-sharpen. Yeah, ilahang gi-sharpen. And then, to the point na as in totally, maoy ilaghi mo nga kutsilyo pang ano bang Bisaya sa pangkat sa meat pangkat sa meat or pangkat sa fish.
Panghiwa.
Sabay Bisaya sa pangkat. Ha?
Tadtad.
Dili tadtad.
Hiwa ra
Chop
sir.
man.
Hiwa,
Hiwa. Panghiwa. So, hait, di ba? Hait is sharp. So kay hait man ang ang hait man ang kilid do sa kutsara, mao to'y gigamit sa amahan. Iyang gi-slit ang throat sa iyang anak. Patay ang bata. Diba? Tapos after that, dili na pwede nagpagawas og resolution nga dili na pwede ang bata sa sud because of that event. Until now, dili magpasud og bata to sa Leyte Provincial Jail because doon nga sa pangyayari na yon. So these are only some of the circumstances, or bottom line, yung the right para doon sa visit of relatives is siya, hindi siya absolute. Okay? So yun. So I think I have already pointed out yung mga ibang concepts na hindi ko na-discuss sa inyo during our regular discussion. So, do you have questions or clarifications as for the totality doon sa mga discussions natin? Dili pwede kay katungod na kay dili man suspended ang writ of habeas corpus. Dapat ilaha ipakita kay unsa may compelling reason nga dili nila ipakita. Nga naman nga dili unsa may balaod nga ilagi patamakan nga dili pwede Mm. Mm. So, questionable mo. Kasi 'di ba ito nga, ito yung reason 'di ba sa visit of relatives, 'di ba ang sabi, 'di ba? Kasi ang taong nadakip daw, yung taong nasa loob ng jail is generally at a great advantage, especially daw kapag sa mga yung affluent or yung mga bagay na particularly sa financial, tapos lacking siya sa mga influential friends. So if ipagbabawal yung pagano sa kanya, how can he post bail? How can he contact sa attorney kung naa siya'y gustong attorney nga kuwaon? Di ba? Mauna nga ang ingon ni Pamaran, moved by these considerations, the framers of the rules thought it wise and fair to give the relatives of the arrested person the right to visit him at any reasonable time of the day and in urgent cases of the night, subject of course to reasonable regulation. So if there are no compelling reasons, give doon sa situation na ibinigay mo sa akin, the police officers have the right to to do that kung ano man yung ginawa nila. Bawal 'yun. Bawal 'yun. Di ko lang klaro kung unsay maging ikaso sa police if that's the case. All right? I'm not really knowledgeable when it comes to that. But one thing is for sure, dili mao ang ilagibuhat. Thank you. Any other clarification or concern?
Ay, ako sir, last sir.
Sige.
With regards atong a person is arrested and has been found out sir upon physical examination na may terminal illness, then 1 year na lang siya mag-leave sir. What is the appropriate action of the arresting officer gani ana sir? Kay ang answer nakabasa ko adto pag after ato ba kay nakabasa ko sa katugaling health parole.
Yeah.
Dili man na sa discretion sa arresting officer good siguro sir no?
Yeah. 'Di ba? Kasi 'di ba yung scenario na ibinigay ko sa iyo, yung scenario na ibinigay ko is naay gi-issue nga warrant of arrest, tama? So naay gi-issue nga warrant of arrest, and then ang question is as an arresting officer. Meaning to say, arresting officer ka, so you have set of kumbaga meron kang limitations kung ano lang talaga yung responsibility mo, tama? So that's how I put my question. So ang question ko is, as an arresting officer, what should you do? Diba? So, base doon sa mga discussions natin, as an arresting officer, if you received a warrant, then your primary duty is of course to serve yung warrant of arrest. Yung intervention na mag-appeal ka kay terminally ill naman na, that's not up to your discretion because you are only an arresting officer. It's up, kumbaga trabaho na yan ng abogado. Kung ano yung remedy nila dyan. Like what happened doon kay Imelda. Kanyo Hello?
Yes sir.
Yeah, yung kay Imelda Marcos, di ba? Naa siya'y conviction. I think that was 7 counts, tama?
Yes.
7 counts. Onya, wala siya gi-aresto. Nag-plea siya og nag-post siya og bail, and then ang iyang attorney is citing yung kanyang edad. So that's why dili na siya wala na siya gidala sa sa detention facility. Can you follow?
Yes sir.
Yung yung case ko na terminally ill, then it's up to the trabaho na yun ng abogado kung ano yung gagawin nila.
Okay, sir.
Any other concern?
No, sir.
Wala na? So baka ma-perfect nyo na yung exam. Promise.
Physical ang exam, sir, like moadto na mi sa UC.
Mauman ang